Today's webinar is on inquiry and notice under the Indian Child Welfare Act, a spotlight on the St. Louis County Duluth, Minnesota Indian Child Welfare Court. I'm Lynelle Hartway. I will be acting as your facilitator today. I'm a program manager at the National Council of Juvenile and Family Court Judges, Family Violence and Domestic Relations Department. Wanted to start off our discussion today with a quick thank you to the St. Louis County Duluth ICWA Court, the Tribal State Collaborative, which includes our presenters today and many others who helped us put together this series, and of course are helping us with our discussion today about collaborative practices. Today, our learning objectives are understand the role of collaboration in ICWA's inquiry and notice requirements, discuss ways in which collaborative efforts have helped improve outcomes for Indian families, and identify ways to incorporate collaborative best practices into ICWA practice. These learning objectives are mirrored in the rest of our series on collaborative conversations. And the goal, of course, is to spotlight key aspects of the efforts of the St. Louis County Duluth ICWA Court's implementation of ICWA and MIFPA, with a focus on how those efforts involved collaboration between and among the agencies, systems, and tribe. For the format for our discussion today, we of course have facilitators, our expert faculty serving as our panel, and our online participants. We encourage our participants joining us today to use our chat function, and we encourage you to participate in the discussion. You should feel free to chime in using the chat function or ask questions as we go. I will be monitoring the chat and will try my best to relay the questions to our panel as we go along. And with that, if we can have the panelists introduce themselves, starting with Judge T.
Greetings, I'm Sally Tarnowski. I am a district court judge for the state of Minnesota. I'm chambered in Duluth, Minnesota, St. Louis County, Minnesota. We started the ICWA court back in, starting with collaborative meetings back in 2014 and ultimately started the court in 2015. So we've been having collaborative meetings and running the court since then.
Thank you, Judge. Rebecca?
Bonjour. Hello, everyone. I'm Rebecca McConkey-Green. I am an attorney in private practice, and I'm honored to kind of serve in a number of different roles. Back in 2014, when the Duluth ICWA Court was just getting going, I was also just starting my law practice. And one of my clients is the White Earth Band of Chippewa, and I do their representation in state court proceedings, including in Duluth. I also am in-house or in tribal court representation for the Boys Sport Band. And then I am a judge for the Leech Lake Band and hear child protection cases in the Leech Lake Tribal Court as well. So I kind of approach this from a number of different areas. I've also spent some time as a court-appointed attorney doing parents representation, both in White Earth Tribal Court way back at the very beginning of my career, and then in state court proceedings around the time that I opened up the law practice too. So it's an honor to participate in the Duluth ICWA Court and also to be here today with all of you. Thank you.
Thank you, Rebecca. Larissa?
Ani buju jingwa kun sendigo mekana kindu dame gaza gaswaj me ka kindu jaba dash nagachu nong and then ga and noki nongom. So my name is Larissa Littlewolf. I'm part of the Turtle Clan and I'm from the Leech Lake Band of Ojibwe. I formerly work with Fond du Lac Social Services as the lead social worker. I worked with Fond du Lac for 8 years, just recently separating from them this past week to take care of my baby. So I'm also a mother of 3 wonderful little Abanujiog, so little Indian babies. So I'm excited to be here and share what I've learned. I've been working with the collaborative since 2018 as the lead social worker. Miigwech.
Thank you, Larissa. Nishah?
My name is Nishah Dupuis. I work here in South St. Louis County in the Indian Child Welfare Unit. I've done ongoing case management in both as a tribal social worker and then here in St. Louis County for about 8 years. So I'm excited to be here.
Thank you,
Hi,
Nishah.
Lisa.
And, oh, sorry, go ahead,
Sorry.
Lisa.
Sorry, we're doubling up here today. My name is Lisa Salo, and I am currently a supervisor in the initial intervention unit here in the South Office in Duluth. Prior to that, I have worked in ICWA ongoing child protection, as well as when our county had an intake unit that was specific for ICWA, I also worked in that unit. I've done child welfare work for about 31 years.
Thank you, and welcome to everyone on the panel. Also joining us is Mark Erickson from UMD, and Mark is going to give us a little introduction to the collaboration practices and the collaborative.
Sure. Thank you, Lynelle. Hi, everyone. My name is Mark Erickson. I'm with the Center for Regional and Tribal Child Welfare Studies at the University of Minnesota Duluth, actually in the social work department. And there I am a researcher and also, well, a Maytag man for everything else too, but also associate project director for the Anishinaabe Bimaldizawag, which is our HHS ICWA implementation partnership project in Duluth, where we also partner with the council on that work. So just to recap, if you're just joining us for this webinar series, the last time we met during our first session, I spoke about some of the mechanics of our collaboration in Duluth, which you heard a lot of people refer to, and the history that's very important and real to us and how we do our work here today. So last time I explained how Judge Tarnowski adapted the physical space of the Duluth ICWA court to put all parties at the same level around the same table. And I compared that to our collaborative relationships that are really as strong as they are, because I think everyone here today would agree that all professional parties are at the same level around the same table. And I apologize, I'm in Duluth, so there's a ship blowing its horn right now. I'm just waiting for that to pass. So the mechanics of our collaborations, they manifest through different meeting groups, such as our Duluth ICWA Collaborative, our HHS project-specific tribal state partnership team, and then a smaller group that includes the judge, a tribal agency attorney, the assistant county attorney, social work supervisor, and a tribal agency supervisor, and then our center director, Bree Bussey, who's not with us here today. I also introduced our agency, the Center for Regional and Tribal Child Welfare Studies, our 5 core values, and explain how they really inform our work from the university with the child welfare community, and how these values have really guided our relationship with tribal and public human service agencies. And then now we're so privileged that they also guide our work with the Minnesota 6th Judicial District in Duluth. And that dates back to 2012, when we participated in an ICWA court monitoring project. And then that relationship has continued with the court through the implementation of the Duluth ICWA court, as Judge Tarnowski mentioned, kind of kicked off collaborative conversations around that in 2014. So these guiding core values that we carry when we work with the child welfare system that I shared last week are collaboration and bridging across systems, a relational worldview, equity and inclusion, education and training, and then something that I think is really relevant to today's topic is tribal sovereignty. That's another value we hold. Basically, we articulate our value of tribal sovereignty as really recognizing that tribes are best positioned to identify what is in the best interest of children from their nations. Therefore, for us, it's crucial to conduct effective inquiry and notice and notify the appropriate tribe or tribes to get them involved in the case. And we often hear the theme up here, nothing about us without us. And this is a theme that is repeated by Minnesota's ICWA Advisory Council, which consists of tribal child welfare directors from all 11 tribes in the state, and representatives from urban areas in Minnesota. And the Duluth ICWA Court has also heard this message of nothing about us without us, and taken steps to ensure tribal representatives are at the table and involved in the proceedings in a way that is consistent and convenient. In fact, we did a data study a few years ago, and when comparing Duluth's ICWA Court data collected in 2018 and compared them to baseline, we saw notice of the petition filing, at least to the tribe, occurred in almost 98% of all ICWA Court cases, and that was a significant improvement over pre-ICWA Court cases where only half of the cases provided notice of the petition filing to the tribe. So as you can see up on the screen here, there's some Minnesota specific stuff. So before we hear from our outstanding panel today, I want to talk about how we implement ICWA in Duluth. So first of all, like several states, Minnesota has incorporated ICWA into state codes in the form of our Minnesota Indian Family Preservation Act, or MIFPA. And the MIFPA tries to make inquiry and notice more straightforward for county agency workers by requiring workers to complete a genogram with the family, sitting down, identifying everyone, ask questions about family, about heritage, and then sending this along with their notification to tribes. And that notification, unlike the ICWA notification, which is the registered certified mail with the green cards that come back, our MIFPA notification includes a phone call and an electronic notice via email or fax within 24 hours of a screened in child maltreatment report. And we know it takes more than changing the rules, but changing the culture of the court system that engages with families and tribes. So the St. Louis County ICWA Court in Duluth is dedicated to a docket of child welfare hearings involving Indian children as confirmed or presumed by definition, as you can see there. And the court looks different, feels different for the parties experiencing it. And that's a really important feature that we have here. And while we recognize that inquiry and notice requirements of the ICWA and MIFPA are best practice that we want to implement, we are by no means perfect in our inquiry and notice practices in our jurisdiction. In fact, I would say we have struggled with this in the past year. However, through our collaboration, we are able to identify and work through areas where improvement is needed, and the relationships, I'm glad to say, have held. So as we spend our time together today, I know our panel will have great things to share with you about how to collaborate and to do inquiry and notice well. I'm so privileged to be able to interact with these wonderful people who are serving on our panel today. And once again, as you look for models to implement in your own jurisdictions, I really hope you get a good sense of how this group from Duluth, Minnesota, works in collaboration, and I'd say in relationship really, to implement the letter of the law, as well as the spirit behind the Indian Child Welfare Act. And with that, I'll hand it back over to you, Lynelle. Thank you.
Thanks, Mark. As I'm sure most of our participants know, the Indian Child Welfare Act was created by Congress after years of hearings. And of the findings that were made and hundreds of pages of documents was about the disproportionate number of Indian children in state welfare systems and its impact to those children, their families, and the tribes. And so ICWA was created by Congress to establish minimum federal standards, and those implementing regulations that went along with those standards were meant to be a floor, and the purpose of which, of course, is to reduce removals and terminations, create stronger efforts to promote reunification where removals had occurred, and more efforts to promote kinship placement, and as a best chance to minimize trauma. In terms of our discussion today about inquiry first, ICWA's requirements regarding completion of the inquiry process. Courts are required at the commencement of each and every custody proceeding to ask whether or not a child is an Indian child, and ask each participant in the proceeding whether they know or have reason to know the child is an Indian child. And this is an ongoing obligation. This collaborative conversation series is an effort to spotlight efforts like those of St. Louis County Duluth ICWA Court, working with the ICWA Collaborative and the Tribal State Partnership to move beyond those baseline minimum requirements of compliance and instead looking at the spirit of intent of ICWA to implement practices, including collaborative practices, to ensure better outcomes for children and families. And this includes incorporating collaborative efforts into ensuring proper inquiry is conducted. So for our first question for the panel, what are some ways where issues around inquiry could be identified, prevented, or resolved? And why don't we start with Judge Tarnowski?
Thank you. So I'm just going to start by saying that the inquiry piece to me is often the most frustrating in terms of real life working with it. You know, we can't have tribal involvement in a case unless we do a proper inquiry and then follow that up with proper notice. And tribal involvement is essential in everything that we're doing. So at the beginning of a case, I always inquire of the parties about their Native American heritage. I am, more often than I'd like to say, a bit astounded that I feel like I'm the first person who's asked. And that's the frustrating part to me, because I surely should not be the first person who's asked these questions. I'm getting petitions that are talking about social services involvement that's been ongoing in many cases for years. And so it's confounding to me that that I'm hearing about a tribe that's not identified in the petition from a parent. And so so it's really critical that the judge asks those questions, because again, I can't say how many times it's happened where we've discovered things that way. You know, obviously it should have been asked many, many times prior to that. So what we've done in our collaborative is and Mark kind of alluded to this, we aren't perfect. And but what we are pretty close to perfect at is talking about things and problem solving. And so what we've done as a collaborative is to put the issue on the table and talk about it. And we talk about it as a collaborative group, and we problem solve it. And so we have met and discussed the fact that attorneys, when the parent attorneys, when they've met with their clients, have discovered ancestors, parents, grandparents who were not identified in a genogram. Their dates of birth were misstated. Their names weren't accurately reflected. And so we've talked about what can we do to fix that. And so, so new forms have been created, new practices have been created. I think others that are going to be talking will discuss that in further depth. But I guess the 2 points that I would emphasize are the judicial inquiry is critical, and a no finding of active efforts if need be, in order to send it back and get it taken care of. I have stayed a finding of active efforts when I thought that something needed to be taken care of along those lines, and come back in 30 days to follow up on it. And then this ability to work as a group to try to figure out how we can start preventing this from happening in the future.
Thanks, Judge. Rebecca?
Thank you. So this is a topic that I could really talk at length at, and I'm going to try to be kind of short and sweet here. But I do want to tell you about something, an example that my husband, who talks frequently on a lot of different issues that affect Native people, uses at times. And I'm doing this in part because the commemoration of this event is this month. in July, we commemorate a tragedy that happened in Sandy Lake. And what had happened there was that a number of tribes and bands in the Lake Superior area were pushed over to the Sandy Lake area and held there for a while. They were brought over there to receive some annuity payments that never really showed up. They were eventually given some supplies that were bad. There was not enough space and game and things to support them in that area. And when they finally gave up and left and went to return home, they got stuck in an early snowstorm and lost quite a number of members. And one of the things that I have heard my husband, and the reason that I wanted to bring this up, talk about is that we all need to stop at times and think about what was the experience that those people that survived remember and that they passed on to future generations. And we especially need to pay attention to that when we're thinking about inquiry, because one of the first things way back when I graduated from law school and was being trained to do this work, that I was fortunate to have very good trainers, and they talked to us about the fact that it is sometimes difficult and feels very unsafe to Indian people to admit they're Indian people at times when they're talking to state actors, and also to provide names of family and information like that. And so I think we always need to make sure that we come at this issue of identification of ICWA cases and inquiry from the lens that people don't feel safe when they're having contact with state systems. And so inquiry needs to happen. You know, certainly there is a state responsibility, and MIFPA lays out processes by which the counties are supposed to have kind of ongoing contact when they have contact with an Indian family. They're supposed to start asking the questions about Native American heritage and identification of ancestors that may be Native American, so that they can identify the tribe and involve the tribe. But that type of inquiry needs to happen with everybody, including the parents' attorneys, because those parents that are so afraid to talk to their county worker about this may be a lot more comfortable talking to their own attorney. And so it's good when there's able to be a good exchange of information. And then that exchange of information, not only between the parents and the social worker and their attorney, but also the other players on the case, whether it's the court or the social workers. So thank you.
Thanks, Rebecca. Larissa?
Thank you. So in regards to inquiry, I really want to stress that building relationships with the tribe is going to be super important. So as a tribal social worker, I got many calls a day just inquiring, hey, is this a band member of yours? Or is this, are they affiliated with Fond du Lac? And they would always make sure, hey, off the record, just calling to check, because, the family resides on the reservation. The family resides within the area. And so the social workers were making those initial calls as inquiry, not notice, to make sure that they were involving the tribe at the earliest point possible. And so that was part of that relationship building that we've done as a collaborative with St. Louis County to really make sure that we're bridging those gaps. So when we talk about inquiry, we're a smaller community, and as part of the Indian community in Minnesota, we recognize some different names. There's some family names that are more prevalent, and we're able then to kind of point the social workers in the right direction to say, hey, you know what, that doesn't sound like a Fond du Lac name. I'll check on it. But why don't you call Leech Lake? I know that in Leech Lake, there's a lot of people with that last name. And so it's a lot easier to have those conversations at the beginning. And being smaller communities, we're able to have those conversations. We're able to recognize members of our community pretty frequently. And so I would say, with inquiry, relationship building with the tribes in your area and with the tribes around you is super important. I've also had attorneys call me and say, hey, did St. Louis County call and make an inquiry about this family with you. You know, they're saying that they checked all avenues, but did they check with the tribe? And so I think that sometimes that's a step that's forgotten. You know, we do inquiry with everybody and anyone in the family's life and trying to figure out if there's American Indian heritage or not. But the tribe can be a resource as well.
Thanks, Larissa. Nishah?
I'm gonna let Lisa talk a little bit first.
So I have to agree, first off, with the judge. I feel like if we're at court and no one has asked about American Indian heritage, we've done a lot of things wrong and missed many opportunities to do so. And so just a couple things that we've done to try to get to a point where that doesn't happen anymore. So for example, you know, the moment we get a phone call from somebody in the community reporting on a family, the screener who takes those calls needs to ask about American Indian heritage. We just created a template that we now cut and paste into the state document that has a section on inquiry and notice, so that it's right there and visible. That's the document that the screener uses to guide them through that conversation with the reporter. Then at 3 o'clock every day, we have a screening team that reviews all of the reports that have come in that day. We're really looking for consistency and screening things in or out. For example, Fond du Lac sits at that table with us. We review all cases that we are aware of, you know, any connection with Fond du Lac with them. And at that meeting is another opportunity to say, did you inquire? Did you inquire with that phone call? And if it didn't happen, okay, go call that reporter back and inquire. So that's another like checkpoint for asking those questions. The other thing we've done that I want to just highlight that Larissa talked about was relationship building. That is key in staff having a comfort level to pick up the phone and call their tribal partners, especially if they're struggling to locate family, identify which tribe this family belongs to. You know, there are times where we might be meeting with a mom or a dad who say, I think I have heritage, but I'm not sure, and maybe it's here, maybe it's there. And so we meet with the tribes monthly. And, you know, over the years, there were times when only our ongoing child protection staff met with the tribes. And I've done most of my work on the front end of child protection. So I've really pushed to ensure that our front end assessment workers and investigators are also meeting with the tribes, building those relationships, so that, because that's where this starts. Inquiry starts with us on the front end. So we meet monthly with Fond du Lac, White Earth, Red Lake, Leech Lake, Boys Fort, all our more local tribes. I also know staff are, you know, with the COVID and working remotely, have become more comfortable doing video calls with the tribes that are a little bit farther away. So Red Cliff, for example, and are building relationships with those tribal partners as well. The other really key point for making sure that we're asking about inquiry is at our pre-petition screening meetings. I'm happy to say that, you know, all of the supervisors, not just those of us who work specifically with ICWA specialists, are asking the question, did you inquire? Did you inquire with mom? When you met with grandma, did you ask her? Did you inquire with the kids? You know, we still often get, well, I don't know who dad is or where he is. Well, let's find him and let's inquire with him as well. So there's many checkpoints in which we can ensure this, this gets done. We're not perfect. We're really just now honing in on what those checkpoints are and what we can do different. And, you know, my hope is in a year, if we were to do this again, the judge isn't going to have to say, yeah, I can't believe people get to me and this question hasn't been answered. So that's my goal, is that judge doesn't have to worry about that in the future.
Thanks, Lisa. Nishah, did you want to add anything?
You know, when I think about inquiry and Lisa and I talked a little bit before this and how it is really, you know, one of those front end questions and things that should be talked about with families, tribal members, right away at that first door knock. But I think too, as an ongoing case manager, I think a lot about what Rebecca had said about not wanting to share that information and how it's important, even as an ongoing case manager, to continue to ask those questions and continue to have those conversations with families. I can tell you that I've had cases that I've had open for a year and we've had conversation and, you know, stories come out from families about, you know, where they're from and who, where they identify with. So it's important to, I think, even in ongoing, to continue to ask those questions. I think, and I shared a little bit in our last session too, but as an agency, a government agency, really recognizing that families aren't going to want to share that information with you because of that historical trauma. And that plays a big part, I think, in the relationships that we have, and that trust that needs to be built back as an agency. So we talk about inquiry at, you know, the very first time we're talking with families, but then also throughout our case, right? Talking about it often and frequently with not just the parents or that we're working with, but also the family members.
Can I add one thing, Lynelle?
Of course.
We've talked about, you know, inquiry and inquiring. I think it's really important to remember that we're not just asking, are you Native American? Are you eligible or enrolled for any particular tribe? My inquiry, and I believe social services will confirm this, that they do as well. When we inquire, we're asking, you know, was your mother, was your grandmother enrolled or eligible? Did you ever go to any powwows? How about any cousins or aunties? I mean, it's a pretty extensive inquiry. It's not one or two questions. It really is trying to get at, you know, did you have any cultural activities that centered around Native American culture? Like I say, the powwows, did you go to any sweats? Did you have cousins who did? Did you have other family members who did? Because that's sometimes where I'll get an answer that will allow me to continue to inquire and find out some information that I would maybe not have heard otherwise. And I don't know if Nishah or Lisa want to expand on some of those questions that are asked.
Sure. When you were talking, what it made me think about is it's a conversation. It's not a question. And so really, you know, working with staff, you know, yes, we provide the training, but then also, you know, throughout our days when we're consulting and talking about their interactions with family, really teaching them how to have a conversation with them and tie, you know, their life and their life experiences back to the possibility that there is some American Indian heritage. And so it is definitely a conversation, and it's, you know, it is something that we can't assume that our social workers understand how to do that and what that looks like, especially when we talk about the lack of trust. Nishah said something earlier, it's the county's and the government's responsibility to rebuild that trust. That's on us. And so, you know, that also plays into, you know, this piece about it being a conversation and building rapport with families, and having that trust with them so that they are open to talking to you about their experiences.
If I could please jump in with something to add, in addition to the historical trauma aspect, one of the things that I forgot to mention is that we also, you know, come from a very recent history of removing a lot of Indian children from their families. And we made the list back in the late 1970s when they passed ICWA, and we're still on the list as being one of the worst states for those removals. That's really important to know, because part of the reason why these conversations really need to be ongoing and not just at the beginning when you're doing the intakes and assessments is that you will at times run into families who may not be aware right away that they have Native American heritage, especially if they were removed or if their parents were removed. Sometimes that stuff comes out over time. And so it's really important to keep developing that relationship and keep having those conversations. It's also really, really important, and I'm glad people jumped in with the how to have the conversation. You don't want to ask if people are enrolled or not. That ICWA does not use the word enrolled. Tribes do and bands do membership determinations in different ways, and they're the only ones that can do the membership determination. So you really want to be having conversations about heritage and culture, and then that will give you ideas of who to notify and let the tribes actually make the determinations from there. Thanks.
Lynelle, could
Can
I
I
just?
add something? Oh,
Oh,
sorry. So like, as I think about this, I think one of the big things that we're all kind of talking about, but not saying, is that it's really important to train the people doing this work, to have these conversations in a trauma-informed way, in a good way, so that these things can be figured out and talked about very openly. And, you know, Nishah's right. This is up to the government to, you know, the agencies to repair these relationships. And in doing that, the workers need to educate themselves on why ICWA exists, like the trauma that these families have endured, and that it's a very recent history. So I've had the amazing opportunity to help train workers. And what I have seen through that is that people do better work when they're informed and when they're educated on why they're doing the work, rather than this is just a legal requirement. And so putting that why behind it is going to be super important for doing good inquiry.
And thanks, Larissa. And you actually just answered a question that we had received in the chat about if it's helpful to the people with whom you're working to explain why you're making the inquiry. And Mark, did you want to jump in?
Oh, I just wanted to stress something that everyone has been saying. Judge Tarnowski talked about inquiry in the courtroom. And of course, no one wants to be called out for not making any kind of connection or determination in advance. But one thing we like to stress in my agency, at least, is this idea that ICWA is everyone's responsibility. And you don't have to have an ICWA court or an ICWA specific docket to follow the ICWA. And I think it's really important, if you're not doing that, just using our jurisdiction as an example, where if a case is presumed ICWA coming from the Human Services, it will go into Judge Tarnowski's court. But if it's not presumed ICWA, it doesn't go in that court. But those judges also should be doing this inquiry as well. So I love Larissa's point about it's a teaching moment, it's a training opportunity. But bottom line, this ICWA is everyone's responsibility.
Okay, thank you, everyone. And now we move on to notice. And with the notice requirement, this is an area in which it specifically, of course, talks about involvement of tribes and the requirements for the information that must go out. So it not only explicitly states the requirements of notice to going to the child's tribe, parent, or Indian custodian, but it also, of course, shows the spirit and intent of ICWA regarding the involvement of tribes in the process, and the need for the incorporation of collaborative efforts into ensuring that that notice is done properly and reaches those who need to know. And that moves us on to our question about ways in which notice can be identified, prevented, or resolved. And Judge Tarnowski, you want to start us out?
Sure. Well, and again, this is, from my perspective as a judge, judicial oversight is needed here to, make a record of the fact that notice has gone out to the various tribes that have been identified, not only in the petition, but also if a parent or someone gives me information in the courtroom, that notice is then followed up and sent. We did find during COVID that some of the green cards were coming back signed by the post office rather than by a tribal agency. And that wasn't good enough. So we did require the county to provide adequate notice that was so that we knew that it was received. And so, and again, if we, same thing is in terms of our collaborative, if we find that there are those kinds of issues where we discovered that the green cards were coming back signed by the post office, just another matter. That we could talk about it and again, problem solve it and figure out what was happening with them. We don't move past the what we call the EPC, or emergency protective hearing. We don't move to an admit deny until all notices have been received, and I am convinced that the county has done what is required of them under the statute under the statute to move forward. So the judicial oversight is a key way to prevent any notice issues, or at least to make sure that the county is doing its due diligence to get any issues resolved.
Thanks, Judge. Rebecca?
So back in 2015 and 2016, I was really honored to participate as an attorney for White Earth with a number of other attorneys for tribes in the state of Minnesota and social service departments and county social service departments on revising some of the aspects of MIFPA, or creating some proposed language to revise some of MIFPA. And one of the things that was added to MIFPA were some notice requirements, some additional notice requirements. And MIFPA actually requires that whenever a social service agency in Minnesota has contact with an Indian family, that they start doing that inquiry process and that they notify the tribe. And so that's even before we're talking about a child being placed out of home. I think that's a really important part. When we just had this discussion about it may take many conversations before you're getting comfort levels and knowledge about people's heritage. Starting those conversations early when you're first providing any services or contact with the family can certainly improve the ability to provide notice appropriately to the tribe and to the right tribe, and get the tribe in and helping provide services right away. And so MIFPA requires that notice be by phone call, and then I think it's or fax or email. And fax or email. So when they do that, so that the tribe is hopefully getting involved right away. The other thing that I would say with notice, I think it was Larissa that mentioned that she worked with Fond du Lac, and they are close knit and a smaller band. I work with White Earth, who is a large band. They have about 18,000 members. And one of the things that was mentioned to me a few years ago was that when there are things like a date of birth that is incorrect on a notice, or a misspelled name, or they don't include the grandparents, or they don't include other relatives that the kids are living with in the notice that goes to White Earth, it really makes it difficult, because White Earth is so large to catch the errors. And so a lot of times White Earth will send back notices saying this isn't an ICWA case for us, or this is not one of our families, when in fact it has been. And so I would really ask everybody to step up their efforts to make sure that the information is full and complete that they're sending over, and to make sure that they are providing very accurate information. Thank you.
Thanks, Rebecca. Larissa?
Thank you. So I think that the one big thing that I constantly go to is if a tribe is showing up late, or showing up to different things at different times, or not showing up to court when usually they do, that there's an issue. So I think one of the things is that I, as a tribal worker, in regards to notice, got really frustrated about was getting a late notice. For families that have already been worked with and have people have an idea that Fond du Lac is involved. And so I know that different tribes have different capacities, but that's part of that relationship building and getting to know the tribe. So if, when a family is Fond du Lac or Leech Lake, and they're usually at the table and they're not, that's a big indicator that something didn't go right for them not to have notice of the hearing. So I think when it comes to notice, making sure that it's done in a timely manner is super important. But then also making taking those steps to build that relationship and have that accountability with the tribe is important, because we also have to remember that tribes get many notices every single day. And so that's part of that, educating yourself and building those relationships to call and to be able to speak with someone and say, hey, I have a notice coming. We have an EPC coming up for this family. Putting it on the tribe's radar is going to be really important so that they can participate at the earliest point possible. And so it's going to be super important to, build that relationship, send out notice in a timely manner, and then pay attention if tribes aren't showing up or if they aren't being made aware of these hearings, and then address those issues as the agency.
Thanks, Larissa. Nishah or Lisa, or both of you?
Thank you. So when I think about notice, and I will be honest, I think we're not perfect. Sometimes we get these things wrong. I really go back to what Larissa said about having tribes receiving tons of notice a day. I know in our agency, there's been some implementation of really making sure that we have checks and balances. So I know that, like, before we send out notice, our county attorney looks at the notices that we're sending to make sure that we have everything filled in that we're supposed to. There's been recent talk about if we have to resend out notice, are we including why we're resending that to tribes so that they understand? I know, I think really forming those relationships and making sure that we're calling tribes to follow up on that notice is important. I've had a case recently where it's been, I think, 4, maybe 6 months, and I've finally gotten a determination saying, yes, these kids are eligible for enrollment. And that's through a lot of relationship building, again, with the families. I think I had talked to many different family members in this family and figured out, yeah, okay, this is where their lineage is, and yes, other kids are eligible for enrollment. So really having that follow through and following up with tribes and having those conversations with family members are super important when it comes to notice.
So a couple of things that I know that we've done very recently to just try to get better at, especially sending notices that are accurate and complete. We have a template that we now put in all file folders for assessments and investigations that is an actual genogram, so that staff can sit with the family and when I say actual, the genogram document in our state system doesn't look like a genogram. It's more linear. It can be very confusing for folks. And so we just created our own genogram so staff can fill that in when they're sitting with families, make sure they're spelling names right, asking for birth dates when families have them. And we're looking at, we have, folks that we call specialists, it'd be similar to a case aide, as well as info specs, which are like a clerk, being able to come back and then hand that person the genogram to ensure that the names, birthdays, etc., are getting into the computer accurately. So just little things like that we're trying to troubleshoot and brainstorm. St. Louis County is a fairly big county. I know that I just looked at numbers, and we had like a 42% increase in maltreatment reports that were screened in from like 2014 to 2016. And I know we've increased, even more so. And so it's like, how do we do things different so that our volume doesn't impact how well we're doing this? And so we're working on things like that. And then I just keep going back to the relationship with the tribes, to be able to call, and especially if we get something wrong, to be able to call Larissa and say, man, we messed this up. Here's what we're doing. Is there anything else you need from us to fix this? Or, that kind of a thing. So it's something that we're definitely working on, and we do have a long ways to go, but I am, impressed with the changes that we've made. I think are having a positive impact. So.
Great, thank you. So I think, as a lot of our panelists have discussed and indirectly and both directly. What ICWA is a step. It's meant to correct wrongs. It identified those problems through the hearing process and then instituted some requirements that were intended to move towards equity, to protect the best interests of children and protect the security of tribes. And by incorporating collaborative efforts and best practices into the systems that are implementing ICWA, that is a step towards ensuring better outcomes for children and families. And that takes us to our final question for the panel. What are some ways that collaborative measures can be built into practice when it comes to both inquiry and notice? Basically your best practice, and or if you had some recommendations for others, what would they be? Judge Tarnowski?
You know, our collaborative really just deals with all issues. And so I would just say it's a best practice to regularly meet with all of the stakeholders and make sure that you are listening to what everybody has to say about each aspect of ICWA and practice, and make sure that you know, nobody feels like they can't bring something up. Everybody is an equal at the table. When something is brought up, it's treated with respect, and we look at it, we talk about it, we problem solve it, and we keep on until everybody is satisfied that we've dealt with that particular issue, and we check back to see, okay, we haven't talked about inquiry in a couple of meetings, for example. Are we still satisfied with the work that we've done to make it better? So it's just really the collaborative itself, the initiating of regular meetings to listen to what people think, how we're doing, what we're doing well, what we're not doing so well, what can we improve on. Those are all things that should be just a regular part of any practice in this area.
Thanks, Judge. Rebecca?
Well, you've heard, I think, both Larissa and Nishah and Lisa talk about, and Judge Tarnowski talk about the importance of collaborating with the tribe and involving the tribe in those conversations. And I would certainly agree with that. They can be a good resource. I would also really encourage people, though, to collaborate and to talk with family members of an extended family, if you have access to them, of the people that you're helping and dealing with. You kind of need to be doing that anyway, to probably be looking for placement options and things like that. But you may also learn some information that can help you both provide services and also determine where proper inquiry and notice should go. And so I would encourage you to do that too. Thanks.
Thanks, Rebecca. Larissa?
I think that the number one thing is to build relationships even when there aren't issues or there aren't concerns. So I think that I really appreciated and value time spent with, St. Louis County supervisors, as well as the judge and other members of the Tribal State Partnership team, to just have discussions about the way our systems work, even when there aren't issues around those systems, or there aren't, current issues around the system. And so I think some of our best planning has come from some of those meetings. Also not being scared to address the issues or the concerns. Talking to the tribe, hey, how is notice going? How is inquiry going? Are you receiving timely inquiry or timely notice? And so one of the things that I think about and saw a huge improvement in most recently is that a lot of the notices are coming from the case aides and the specialists, not the ongoing workers or the investigators or the family assessment workers. And one thing that I did notice more recently is the case managers and the social workers are calling to say, hey, did you get my notice? Hey, was notice sent to you? So it was another way of kind of those checks and balances. So that within that agency, within that system, there was more going on to check that. And so there are times when everybody is overwhelmed, including the tribes. You know, like I said, we get hundreds of notices in a week, and it's being able to just have open conversations of saying, hey, you know what, Nishah, I got your notice. I haven't been able to respond to it yet because we've had a lot, and having that mutual understanding, but not letting it go too far. Whereas if I'm not responding to a notice, or a notice isn't being sent right away, holding the other person accountable and the other system accountable is super important as well. So having respectful professional relationships, super important, and being able to have open conversations about issues, very important as well.
Thanks, Larissa. And Lisa and Nishah, you guys get the last word. We are running up against our time.
Thank you. I really hear everybody talking about the collaboration with the tribe, which is so super important. I think we've talked about that in both of these sessions, but also that collaboration with family, something that St. Louis County does very well. And I really appreciate our model is safety grounded organized practice. So having those safety planning meetings with families and being able to talk to them about, you know, who their family is for the inquiry, and then where they're from, asking those different questions. So being collaborative on all levels, not just amongst professionals, but being collaborative also with those families is super important in the practice that we do and the work that we do with the people that we serve.
Yeah, I'll disagree with Nishah real quick. That was the one thing I thought of. We do have 2 full-time positions that their job is to run family meetings, and our goal is to do that early before a case gets to ongoing child protection. And so that collaboration at the higher level, as we are all collaborators that are sitting here today, but as well as collaborating right away with the family on the front end and learning as much as we can about who their supports are and who their system or who their people are. So.
Well, thanks everyone. And I had planned, of course, to solicit any final thoughts that you wanted to leave us with, but we are right at our 11 o'clock. I just want to provide a quick link to some resources at the NCJFCJ website, and then everyone's contact information. We did have a question come in right at 11 o'clock from Jeff Kushner. If there's a standard set of questions that should be used for inquiry that is culturally respective, like a short screen for this purpose. And Jeff, there's everyone's contact information here. You can feel free to reach out to me, and I can follow up with our panelists and see if we can get you a longer response. That works for everyone. Thank you so much for our panelists and for our participants. I appreciate your time and all of the interesting information. It was wonderful. Thanks so much.